So if you would like to welcome Kate back up, that'd be much appreciated. Thank you.
All right, now I don't want anyone to be falling asleep because I know what it's like. If you're like me and ate a lot of carbs just then, you tend to get a bit tired after lunch. But this stuff is probably the really important stuff for you guys. So we talked a bit before lunch about the foundational aspects or the information in relation to trademarks and that kind of thing. What I want to talk about now is the top 4 issues that, in my experience, I've come across that commonly affect clients that I've worked with in the NFP sector. And we should hopefully have a bit of time at the end for questions, but if there's something that you really want to ask, just pop up your hand and interrupt me. Okay, so these are my top 4. The first one is conflicting brands. So I'll go through each of these, but that's where I was talking about where you get that brand confusion. You're using, and descriptive brands and conflicting brands can often be related. And it can also be issues of trademark infringement under that conflicting brands issue. So we'll go into that in a minute. The second issue that is very, very common is descriptive trademarks and trying to protect them and trying to stop others from using similar ones. The third issue is brand management. So, a lot of the non-profit organisations have an incredible amount of volunteers. There might be quite a bit of turnover. Keeping good records of your use of your intellectual property is probably non-existent. And I can tell you I've had some really awful days where I've had big boxes of evidence sent to me from a lovely client, and to sift through that, it's not a lot of fun. And so I'll talk a little bit about some strategies with how to deal with that and what you can implement that should hopefully be fairly cost effective and not too resource intensive. And the fourth issue, which I didn't sort of talk about copyright in the first session because of time constraint, so I'll cover it in one hit at the end. A major issue is copyright ownership. And a lot of the times you probably don't even realise that you may not own the copyright in a lot of the work that you think that you do. So without doom and gloom, there's always a way around these things, and it's just about making you aware of it, and we'll talk about a few strategies that I've experienced as being useful for the non-profit sector. Okay, so the first issue I'm talking about is conflicting brands. So you've got that issue where you've got similar objectives, and you may have very similar names or a similar branding campaign, that kind of thing. So that kind of confusion can obviously lead to donations being diverted to the wrong organisation, which is a terrible thing to have happen to you. It's also very, very difficult to be able to protect it if somebody's already using something similar, especially if they've got the trademark registration. And then that brings me to the issue of infringement. So if they're already using something similar out there and then you go out to market and you're using it, it's not too late, but you're already infringing. So most of the time, non-profit organisations are quite happy to allow you to just rebrand without taking any action. Unfortunately, that's not always the case, and I've had to have some hard conversations with clients about playing nice, but there are lots of fights that happen because you get very vested in the brand that you've created and that you protected. And so I guess the important thing is, if you're not taking steps to mitigate it up front, then you've got that risk of infringement. And a couple of other issues, which I'm really not going to go into because it just gets too overwhelming, particularly after lunch, is misleading or deceptive conduct, and that's related to consumer law. Okay, so that's something that if you have had any issues with that or if you have any questions about it, you can come and talk to me later. On my website, I've also got all these frequently asked questions that you can go and have a look at as well. And the other one's passing off, and that's something that is kind of similar to trademark infringement, but it relates to unregistered brands. So if you're not using it, or if you've potentially got packaging or you've got services that are packaged up to look similar to someone else's. Okay, so how do you avoid it? Well, the first thing that you should do is get something called brand clearance done. And ideally, although this very rarely happens, is Get it done during the stage of development of the brand. Don't wait until it's gone to market. And don't wait until you've already decided on what you're doing, you've paid your wonderful agency, or you've paid your graphic designer to do it, because then you're going through that whole process of having to pay for it again. What I often recommend doing is working with me at that stage to actually do some initial searches, and it might just be that we just do what I call knockout searches, where we just make sure that there's nothing out there that's going to be a big issue at the start, that's going to be a risk to you for infringement, or that's going to prevent you from being able to use and register the brand. And I think I've covered all that, so we'll skip to the next slide. And then once you've done your clearance and you know where you stand with your brand, and part of that brand clearance is to get a strategy that says, so usually I would do a brand clearance search, and that means I search all the trademark registers, I search all the government publicly available registers, so I search ASIC, business names, I also search public directories like white pages, yellow pages, social media, everything to check, and then to give an advice on whether or not from a legal standpoint you can use and register it. I have lots of clients say, but I think it's different. Well, the judge doesn't care what you think, so we go through that stage, and then it might be that I come up with 5 different options for you from a brand protection strategy perspective, and say, okay, look, this is what you should, this is ideally what you should do, but this is what it's going to cost, and then, okay, let's look at option 2 and that kind of thing. And most often I will recommend some form of trademark registration, because I think it is the most cost effective and legally the most effective way for any organisation, whether they're private or non-profit, to protect their brand. And so once we've done the clearance search, second thing is to get it registered. It will make it easier for you to be able to stop anyone else coming into the market using a conflicting brand that might divert those services or negatively affect the reputation of your organisation. And more often than not, just a really simple, you don't need to send a nasty letter from a lawyer straight away. Sometimes what I think the solution is that I draft an email and it goes out from you as the CEO or as the brand manager for that particular organisation. Just go, hey, guess what? I've got a trademark registration. We've got a trademark registration, and let's find a way that we can resolve this so that we can both work in the same market without being confused. And more often than not, that's enough. Sometimes you unfortunately have to go to the next step of a letter, but most of these organisations aren't resourced like yourselves to fight it, and once they realise you've got a registration, it's game over, and most lawyers who see that will say, it's game over, rebrand. And so it also acts as a deterrent, as I said before, so it's about getting that trademark registration, other people see that you're registered, use the R symbol, use it correctly, and it can show people that you're serious about your brand and that you are willing to enforce it. And as I said before as well, it's also great for fundraising if you want to be able to license your brand. It's not an asset until it's registered as a trademark, so it makes it a lot easier. And from a liability perspective, most commercial organisations will require you to have a trademark registration, whether you're in the not-for-profit sector or not. So I've worked for major events where it was a requirement from sponsors that all of the brands were registered so that they knew that they weren't going to have issues with it being used in relation to their brand. Okay, so the other issue, and these aren't necessarily in order, I think descriptiveness is probably the biggest issue that comes up in the not-for-profit sector. And I think that's because we want to use words that describe what we do, and we think that makes it really easy for the public or for potential donees to say, okay, I know what you do now, I'm going to donate to you. Well, that's great, except if everyone else in your market who has similar charitable objectives and calls themselves something really similar, it makes it extremely difficult for the public to be able to remember who you all are. And I can say that as a consumer and a person who donates monthly to different organisations. I've been confused several times with different animal organisations and that sort of thing, and I don't even know if the one I'm actually donating to at the moment is the same one that I was last year. So it's very confusing. They're also notoriously difficult to register. So the rule of thumb with a trademark we talked about before is that to register a trademark, it needs to distinguish, not describe your goods and services. So if you try to go to IP Australia, and I might ask you to put your hand up in a second if you've experienced this, you've gone to register your brand as a trademark, and they've come back and said, I'm sorry, but other traders need to use your trademark, those words, to describe the goods or services that they're providing, and therefore it's not able to be registered. Out of interest, has anyone attempted to register a trademark with IP Australia and had it rejected on that basis? Put your hand up. Yep, a couple probably don't really want to put their hands up. It happens all the time, and trying to then get that over the line, particularly if it's descriptive, even using a lawyer, it can be extremely expensive, unless you have someone who's really nice and willing to do it on a pro bono basis. And it's almost impossible to satisfy the requirements of reputation to get that across the line. And so the more descriptive it is, the harder it's going to be to protect. So, because you need to show that it is a sign and it is your badge of origin and it is distinct from other competitors, and that they don't need to use those words to describe their goods or services. It's very hard. And we also talked about brand confusion and diversion of funds. And the other thing I wanted to say in the online world is it gets lost in the online market. So if you're doing searches and all you can think of is, they were called cancer something, well, if you do a Google search of that, or if you do a Google search of any of those particular areas, you'll get so many hits and they all sound so similar, it's very hard to distinguish them. So even if you do have a device or an image which will help to distinguish it, that phonetically isn't, unless they go in and start looking at each one, they're going to be relying on what the name of the organisation is. Some of you are looking a bit depressed. I'm not going to disillusion you. I've worked with clients in both sectors and I've had to have hard conversations with them, but it's better to be informed about these things and to be able to make informed decisions down the track for your organisation than to wait until the S hits the fan, and that's when it gets expensive and difficult to try and rebrand and do something different. And sometimes it's a matter of just changing one word. I said to someone before, we had a client who was very devastated that she couldn't use the brand that she wanted to use, and all we had to do was change one word in it, and she's had no problems. So there's lots of different ways around it. It's about just finding those commercial solutions. Okay, so speaking of which, there is obviously the rebrand issue if you want to overcome a descriptive trademark, and as I said, it might be just something really minor, like changing one word. It might be just using those descriptive words that you currently have and then adding something really distinctive with it. So I'm not saying there's nothing to stop you using descriptive words, just don't use them as your brand, use them with your brand. So use them underneath your brand, use them next to your brand, use them as part of the search engine process online, but then have something really distinctive. It can be one word, it can be two words, that people are going to then recognise it. Okay, well, I've done the searches and this is one that's come up and I recognise that one immediately because it's called Red Kite. That kind of thing. The other option is that you can build up a really significant reputation. So spend time, usually it takes 2 to 3 years, keep good records of use, which I'll talk about in a minute, and really build up that brand presence in the marketplace and then try and apply for it later on. And sometimes by that point, if you've got good records of use, we can lodge the evidence with IP Australia on your behalf and say, okay, look, they have a reputation now. The other option, I guess the disadvantage with that one is that in the meantime, while you're waiting to build up that reputation, somebody else may have already gone and applied to register the trademark. So, yeah, some people are definitely looking very depressed. Maybe you should come and talk to me afterwards. It's not that bad. And then the last thing that I talked about a bit earlier is just adding those really distinctive elements to your brand. So it can be a unique image if your brand is very much a visual thing. But if it's about phonetics and about sound, then think about adding that one word that might be really unique, that can just be so simple to change. And I say that loosely because not all committees are very good at changing things very quickly. But just that one change is what you'll need to do to just simply make it unique. And if you put it at the start of the brand, this is a very generalised comment, it's got better prospects of getting registered. So have the more distinct elements at the start of your brand. And the reason for that is because that's how consumers recall things. It's usually the first letter and the first word. So that brings me to brand management. Now, as I said before, often NFPs have a lot of volunteers working for them. They lack the resources and the funds, and they don't even think about. I'm fairly confident that more than half of this room hasn't thought about brand protection until now, and you don't keep records of use. And so when it does come to that point, and maybe you've already been operating for 5 years, and you go, well, we've been operating for this long, we've already got a reputation, we don't need to rebrand. You need to have those. It's really important to start putting together records of use as soon as you can. So that's things like all your corporate stationery as you change over time. So it might be different promotional material. So when you're doing campaigns, keep records of it if you can. Just keep a folder and just dump it all in there, or do what my client did and just chuck it all in a box and send it to the lawyer when it comes time to register. All of that stuff is use. Everything that shows your reputation, everything that shows how you're using it, even your email signature where you're using the brand and consistently for a period of time, all of that is record of use. And ideally, but we might be taking this a bit too far, is to keep an IP register. So keep a register of when you register your trademarks, and keep a register of different copyright material that you develop for the organisation. Put the dates in of when it was created, and keep that in one single spreadsheet and just keep updating it that way. That's all you need. So particularly for not-for-profits where it's not about evidence of profit margins and all that sort of stuff, which the private sector need. So we've sort of talked a little bit about this, but in terms of the implementation, so there are things I think as well that are really important, like a brand use manual. So that can include the branding guidelines that you can get from an agency. So when they develop the brand, they should also develop up some branding guidelines to make sure that you're using the brand consistently in the marketplace and using it as a trademark, not in a descriptive sense. So I guess an example is a client who had a tagline, and it sounded quite unique, but at the same time, what they were doing was they were using it in a descriptive sense through their entire, all of their material and content. So without being able to say what it is, unfortunately, essentially what they were doing was they'd say something and then they'd say the tagline after it, and it sounded just like they were describing what they were doing. And that wasn't used as a trademark, so it wasn't able to be used as evidence. So if you have a good brand use guidelines manual which talks about how they use it and using the TM symbol, using the R symbol when they can use it, how to make the brand look consistent. If you've got members who are using your brand, or you're permitting them to use your logo, have a system in place in that branding guidelines and make sure that they stick to it and control the use of your brand. It's really important. So we've all heard how important a brand is. If you're not going to protect it, and part of that process involves enforcing it, then what's going to happen is it's just going to become diluted in the marketplace and it's going to lose that value. And the other important thing is to think about now with what we're doing with the online world is to get some sort of online use system, particularly with copyright, and even a social media policy. So, and I'm not just talking about from an IP perspective, I think this is important from a risk management perspective as well, but just think about how you're using, because information and IP is so freely available on the internet, try and put some parameters around what you can and can't use from an infringement perspective with your volunteers, as well as from protecting your own brand and its integrity. So, simple things like if you're going to be putting promotional material and posting it on your Facebook page for the organisation, have a watermark with your branding in the background, or have something on it to make it difficult for it to be replicated. There's lots of things that you can do that isn't going to cost you a lot of money and can be a really effective deterrent. Okay, just the final issue that I want to touch on briefly is copyright ownership. So we've got some fact and fiction again. So what I'll do is I'll get you to raise your hand. I won't make you stand up. So hands up if you think that your organisation owns the copyright in its logo. Yep. And what about the collateral? So when I say collateral, I mean in your publications, in your promotional material, in your training materials? Hands up if you think that your organisation owns all that material. All right, put your hand up if you agree with this. Not that it's happened to you, but that's our idea and they stole it. They can't do that. So, yeah, so it's wrong to, well, yeah, it might be morally wrong, but it happens a lot in campaigns for not-for-profits. Okay, so last one. Copyright notices should be updated to reflect the current year. Put your hands up if you agree with that. Well, that's kind of good. All right. Okay, I'm not going to go into this in too much detail because you've got the slide there, but essentially the main things you need to know about copyright is it's protected automatically in Australia, so you don't need to register it. So if you get a shonky notice in the mail, which happens all the time, and says, register your copyright with us, it will be a scam. So you don't need to register it. The only country that I currently know that do it, that you'd even consider doing it in, is the US. But in Australia, no. Automatically protected from the minute it's created. And when I say created, I don't mean the idea, I mean the expression of the idea. And that's what brings me to the second point about it protects the originality or the authenticity of an expression. So most often we think of copyright, it's artistic works, it can be a logo, it can be, music, different performance, right? So if you've got people doing dance, that sort of thing, all of that stuff is if you think about the creative arts and the arts world, that's where copyright falls under, and also under writing and all your different collateral that I talked about before. One thing that you need to remember though is that whilst you can rely on copyright for your logo, so for the image, it doesn't protect a word and it doesn't protect a slogan. And the reason for that is because they're not original enough or authentic enough. So just having a word is not, you haven't created that material, and it's not particularly original. So it won't be protected by copyright. But other than that, it is a fantastic tool for protecting all of your images and your promotional material. And I've already talked about that, so we'll skip over that, but that just is to give you a bit of an idea of some of the material that might be in your organisation that could be subject to copyright. Now, here's an issue that commonly comes up, copyright ownership. Often you might use contractors because you can't afford to have permanent employees, and most of you will use volunteers. Now, under the Copyright Act, if you have employees, the presumption is that the employer will own the copyright and will own it in all of the material created by that employee, subject to some specifics, but essentially that's what it is. That's not the assumption. That is not the case for volunteers and contractors. So if you contract with a graphic designer, you need to make sure that in that contract it says that the IP will be invests in you as the client. So otherwise, technically they own it. So, and a lot of the times that's fine. It doesn't matter. Things move along and there's no issues. But sometimes that doesn't happen. And unfortunately, I had a situation with a client who had rebranded and they engaged a contractor. A graphic designer actually, he developed it. They were really happy. They went to market. And then when we were doing the brand protection, because yes, they went to market after they before they came to see us to do the brand protection, we said, what about the copyright ownership in the logo? And we found out that they didn't own it. So then when we tried to do up a simple one-page assignment document, it's called an assignment, it's essentially a transfer of copyright to this graphic designer, all of a sudden this organisation was quite big, even though it was a not-for-profit, and they'd already gone to market and they'd already invested in it. So they were really in a poor negotiation position with this graphic designer. And so the graphic designer sadly wouldn't assign it over without quite a bit of money. And so we had to rebrand. And so after that process, it was actually cheaper for them to rebrand than to have to pay this guy out because he was being difficult. Unfortunately, fortunately, most graphic designers aren't like that. And it's not a particularly great way to run your business, particularly with not-for-profit. But if you can think about it from a commercial perspective, it's really difficult when you're already out to market and you're doing all this stuff and you've built a reputation to then say, oh, now I want to own the copyright in that logo. Do it when you're engaging these people and make sure that's clear. And it can be really simple. And most of the time at that initial stage, because they want to give you the service, they're more than happy to assign it then. So just make sure it's in the contract up front. And again, please don't freak, it's not doom and gloom, and most people are more than happy to assign the copyright. It's just a really simple process, particularly in the not-for-profit sector. Yes?
This is kind of a two-pronged question, but in a state government-funded service, there is issues around IP, but then if we come up with a particular way to use, to put information that makes it easy to find things, and we want to, is that to copyright that? Is that
so yeah, it might depend on the terms of the agreement. So for a lot of interactions with, it is different for governments. So the government has been very clever and put in provisions that say that the government owns all IP created by its contractors. That's the, so if you're dealing with government organisations, just bear that in mind. But yeah, you know, it depends on what the terms of that particular agreement is. It might be the case that if you've developed something that's outside the scope of the work that you're doing for that organisation, and that's the same as an employee, if it's not within your job to create that intellectual property, then it's a grey area, but you don't, you know, your employer doesn't own it or the state doesn't necessarily own it. So it just depends on how it's created. Unfortunately, I hate to say it depends, but that's, yeah, it's very circumstantial. But I'm happy to have a chat to you afterwards at afternoon tea. Okay, so I think we've all got a bit of an understanding of that now. And so, as I said, make sure that you are getting, yes?
I have a question about board members are not-for-profit.
Yeah.
They're volunteers.
Yep.
So anything they create in the course of
Yeah.
being on the board is outside the auspices of the organisation in which
Yeah, there's other things, and maybe Derek can help with this in terms of compliance and their obligations as board members to the organisation with respect to things like fiduciary duties. But technically, you need to have something in place that would say that they transfer all the IP. And I actually had to act for a client, and I say had to because I didn't want to, because I don't like taking these matters to court. We had to act for a client who was a board member who had been thrown off the board, and he had all of his material that he'd created then repurposed and sent out, and they had wrongly attributed it as well. And so we had to go to the federal court over that and mediate. It was an expensive and ridiculous process, unfortunately, but they didn't want a bar of it, and really all this person particularly wanted was some acknowledgement or to have that conversation. So, you know, I'm a lawyer and that's what I do. I haven't always been a lawyer. I've worked in the commercial world, and my job before being a lawyer was to settle disputes without getting lawyers involved. So there are always, yeah, I used to not like lawyers either. But there are always ways around things. It's about being commercial, knowing your rights and knowing what leverage you might have, but being commercial and fair about these things. And so just going back to this quickly, because I want to make sure that you understand that with these agreements, you have a provision in the agreement or the terms that says automatic vesting of IP upon creation, okay? So when it's created, it's automatically vested. Because there's always a bit of a dicey area about agreements to agree, so have it vested straight away, but then make sure there's another provision there that says an assignment of existing and future IP from the volunteer or the contractor to the organisation. So that's kind of a double whammy just to make sure that you're covered. And then having another clause that says that basically they'll do everything reasonably, that's commercially reasonable for them to do, nothing ridiculous, but they will sign over anything if required. So if there's any issues down the track, they're bound contractually to sign something to say, yep, I'll do everything to give effect to that assignment. And I'm not going to go into this because we're not going to have too much time, but there is another area within copyright called moral rights, and it's very important to understand from the perspective of attribution. So if someone creates the work and then they own it, but then even if they then transfer it to the organisation, there are still aspects of a right of attribution. So you can't sort of purchase work off someone, you get a volunteer, they do a presentation, you take it off them, and then you put your name on it as the CEO or the board member and say, this was by me. That's actually a moral rights breach, and you're not allowed to assign moral rights. So there is a bit of a grey area there in terms of what's assumed. There's different cases that say, look, if you're creating the work for the organisation in this capacity, it's not they don't expect that you're going to be attributed for it. But you also need to make sure that you're correctly attributing people's work as well. But I'm not going to go into too much of that because it doesn't come up very often. And lastly, I just want to make sure that you understand with copyright notices, because I see it done incorrectly a lot, including in the private sector. When you're doing a copyright notice, it's not compulsory, but it is a really good deterrent. And it does remind people who don't necessarily want to do the wrong thing. So if you've got a copyright notice on material that's online, they'll think twice before they just blatantly reproduce it. So what you do is you have the C with the little thing around it, and if you've got a computer like mine, it will just do it automatically. I say that, I'm not very technical, but it just does it. And then you put the year that it was created, not the current year, the year that you created it, because that's when the protection starts. If you have updated your website, and there might be other, and that happens all the time, so you've created the work, say you created the website in 2009, and then each year you're making fairly substantial changes to it, you can put 2009 to 2015 because there's multiple copyright works within that website. And then put the owner of the works, which will be the organisation hopefully, and you can add all rights reserved. That's a bit of a legal silly thing we do, but... and at the back of I'm not going to go through these now, but at the back of the presentation, I think from the one before lunch, I've just replicated this in a larger document so it's easy for you to see. Essentially it's a summary of what I've talked about and what my recommendations are of things that you can do. And I think the main thing I want to stress just before we finish up is that I don't want you to feel overwhelmed with this information, or I don't want you to feel like it's doom and gloom. It's not. It's just about recognising it, being aware of it, and then knowing who to talk to get the right advice or to get assistance, and just to make the correct decisions as you go down the track, because it's so much worse to see clients. I don't get any satisfaction out of clients coming to see me when things have gone wrong, because it costs them 3 times as much, and it's emotionally very stressful, and good people aren't equipped for that sort of stuff. So it's all about learning and empowerment. And if you have any questions or concerns, or you feel worried, you can always just send me an email or give me a call, and I'm happy to do some initial consults with you because of the not-for-profit status. And I also offer generally around 50% off for not-for-profit work within reason, depending on what the work is. So, yeah. Was there any other questions? No? Yep, sorry.
Can you start by expression of idea?
Yeah, okay. So say if you come up with a really cool idea, like for an app, you go, I really want to, that would be such a good... I come up with these ideas all the time, but I don't express them. And so I might come up with the idea in my head, but so might 5 other people around the world, and that's okay. These are ideas, but it's the way that you express it that makes it original and authentic and creates the copyright. So having something in your head is not copyright protected. It's the individual expression of it. So you might have 5 different people look at a tree and all paint it individually. The idea to paint the tree is not copyright, but the different originality of the way that each of those 5 artists paint that tree is their own individual copyright. Does that sort of make sense? Great. Yep. Okay. Great. Thank you.
Thank you very much, Kate. Much appreciated.